Right, so it looks like our attendance has finally been at a standstill for about a minute. So if you're ready, Zach, we can get started.
Sure.
All right, everyone, thank you for attending today's webinar. We're happy to have you and to hopefully provide some insightful and useful information for young lawyers and even experienced lawyers that you might not have known. Before we get started, just a couple of housekeeping matters. First, I'd like to remind everyone that the upcoming MDTC winter meeting is going to be occurring in person at the Sheraton Hotel in Novi. This year, we'll be talking about the topics of how to get business and how to get business done. And then just a quick reminder that next summer in 2022, June 16th through the 17th, we'll be having the in-person summer meeting, location to be determined. The topic is a defense-oriented discussion to an ever-changing legal landscape. Please sign up for both of those events if you're able to. I know I'll be attending the meeting next week, and I've always left with some bit of information I can put into practice from that. And with that, let's turn to today's topic, a courtroom trial attorney in the public policy and regulatory world. Our speaker for today is Zach Larson. He's an attorney with Clark Hill in Lansing, Michigan. Zach's practice focuses in the regulatory landscape as well as environmental law. And my introduction can't do him justice, so I will gladly hand over the mic to Zach to start our presentation.
All right, well, thank you, Brandon. Let me get my slides up real quick. As you mentioned, the topic, oh, sorry, hold on. I think I've got, let me go back to that real quick. All right, there we go. As you mentioned, the topic here today is courtroom trial attorney in public policy and regulatory world. And I believe you should all now be seeing the full screen of my presentation here. My name is Zach Larson. I'm an attorney at Clark Hill. As Brandon mentioned, my background, which I'll get into in a little bit, is in regulatory and environmental matters. I want to talk to you for a minute about what we're going to cover today. You all, obviously, if you're here, you received the email and you've seen, generally what we're going to cover. But I want to talk a little bit more detail so that if for some reason you misunderstood, we're not going to hit on something that you really wanted to learn about, then you can take a minute to decide whether or not to stick with us. And or know when to tune in really and when you can tune out. So our theme today is the core concepts that are at play in litigation involving the state or where state action is in the background of the litigation. And we're going to talk about a number of things, but we're going to start with the question of what are the key questions to ask when you first receive an inquiry from a client about state action, some sort of a letter that came in the mail, or maybe it's a broad policy that's been put into play by the state. What are the questions you need to ask to orient yourself about what your options are for challenging that state action? Then we're going to talk about administrative agency appeals and contested case procedures. We'll talk about the unique requirements for civil suits, original actions against the state. And then we'll talk about the main APA substantive comments or substantive concepts, such as the limits on an agency's authority and the nature of administrative rules, and the ROVIS respectful consideration standard. That is, when do you or whether you defer to a state agency's decision. A couple of things that we're not going to talk about. We're not going to talk about federal jurisdictional constraints on suing the state. So we're not going to talk about, for instance, the 11th Amendment or Ex parte Young. And we're not going to talk about the Government Tort Liability Act or other immunity concepts such as qualified immunity from Section 1983 students. So we're really going to focus on the procedural questions under the APA, the core APA concepts, and the Court of Claims limitations with respect to suing the state. So really quickly, my background, why would you listen to me? You know, what experience or expertise do I have here to share with you? Well, first of all, I spent 4 years or 3.5 to 4 years working in state circuit courts as a judicial law clerk. So I've seen administrative appeals from that side of things as they come to the circuit court. I spent 8 years as an assistant attorney general. In that capacity, I litigated for 4 years revenue tax cases or Revenue Act cases, tax cases that are sales use, business taxes, and a lot of those going up to the Michigan Court of Appeals and involving administrative law concepts like administrative rules or agency deference, or when fact finding might be overturned from the tax tribunal and things like that. I also then spent 4 years representing the state of Michigan in civil lawsuits involving Flint water, as well as in environmental matters involving air and water, where we were representing Eagle, formerly MDEQ, in environmental enforcement or permitting actions, including in contested cases. Since January of 2020, I've been at Clark Hill. I have a regulatory practice, including principally environmental matters, but also things like insurance receiverships, where we've been litigating, I was talking to Brandon about this earlier, over what authority a insurance rehabilitator has. Or we've filed industry-wide lawsuits involving Michigan's large livestock farmers and the environmental regulations that they're facing. I've also been involved in the Midland flooding litigation, the Edenville Dam, post-Edenville Dam collapse litigation. And I've written about administrative law concepts. So for instance, you know, the issues that we're going to talk about, the Rovis doctrine, or you know, the nature and scope of administrative rules and the procedures that are required for administrative rules. So all that to say, I know a little bit about this topic, and I'm happy to be presenting today. So getting back to that initial question, the hypothetical of, okay, a client comes to you and is asking, hey, what are my options here? What do I need to do? I've received a letter in the mail, or maybe there's this broad policy that the state has started to implement, and I need to challenge it, or it's affecting me in some way. What do I do about it? What are the questions that you need to be asking? Well, I think there's really two main issues that you need to dive deeply into, and that is, first of all, is this an action that's unique to you and your client? Is it directed at your client, or is it a broad policy that's going to affect a lot of folks? As we'll talk about later, that's really going to the question of, are you going to have a unique remedy that you need to pursue at the agency level? And then there's this question of, is the state engaged in administering an act that it is legislatively delegated to administer, or is it acting in some other capacity? Is it acting in a proprietary capacity or some general capacity? If you look at this matrix that we have here, answering these questions is going to help point you in the right direction. It's not going to necessarily give you a clear-cut answer to begin with, but it'll get you moving in the right direction. If this is administrative, if it's, you know, they really are applying a law that the agency generally administers, and that's the capacity the state's acting in, and it's directed at your client, then your first thought needs to be, somewhere in the substantive statute, I have an ability to try to correct this through the administrative agency, and that's where I need to go. If this is administrative, it's being done by the agencies administering their law, but it is broad and it's applying to a lot of different folks, then maybe instead what you have as a remedy is filing a civil suit that's on a broad basis as a declaratory action, raising legal issues that your client might have to challenge the particular policy. And if instead this is being done on, in some capacity other than in the administrative capacity, then most likely you're looking at a civil lawsuit in the Michigan Court of Claims or potentially elsewhere, but most likely in the Michigan Court of Claims, and you're going to need to consult the Michigan Court of Claims Act. So let's start with the first question. This is something that affects your client directly, and you've got to take an administrative appeal. So what does that look like? Well, for starters, you have, under the Michigan Constitution, a right to judicial review of agency actions if they are final decisions, findings, rulings, and orders of an administrative officer or agency exercise or existing under the Constitution or by law, which are judicial or quasi-judicial and affect private rights or licenses. But the question is this really a final finding or ruling or order of the agency? Because if it's not, then you're going to be required to pursue it to the point of finality at the agency level. And that means, that's the catchphrase of exhausting your administrative remedies. So that means if you have somewhere under the substantive law where the agency can potentially correct or change its decision, then you need to make sure that you give them the opportunity to do so. The rationale for that is generally, there are several reasons, but the first rationale is this is a separation of powers question. If the legislature has determined that an administrative agency or tribunal has exclusive jurisdiction, then you cannot sue in a court because the legislature has given that question to the executive. And so deciding that, figuring that out is a question, as these cases up here, L&L Wine and Pappas point to. It's a question for the substantive law that on which the agency decision is based. You've got to look to that law and determine whether or not it has committed exclusive jurisdiction to the agency. The other reasons for this doctrine include expediency, meaning that, presumably an agency could act quickly and solve your problem, and that will take less resources than going to court, which is the flip side of the coin, another rationale that the Michigan courts have given, which is judicial economies. And then lastly is the expertise of the agency. And really, until it's a final decision, until it's something that's been worked up by the agency, the courts don't want to touch it. They want to make sure that they get that when it comes to them with a full record, with a full understanding of what the agency did and why it did it. There are some exceptions to exhaustion. One of those exceptions is if it's presenting strictly a legal issue, and that might be something that you can file as a declaratory judgment action. There's also exceptions for challenging the authority of the agency to act. If they don't have the authority in the first place, then it would be inefficient for you to take this through an administrative process. And in that instance, you have a right to take it to court and to challenge their authority to be acting in the first place. So where do you find these remedies? Well, you're going to find them in the substantive law that governs the agency action. So for instance, you have, for environmental laws, which I'm very familiar with, NREPA, the Natural Resources Environmental Protection Act, in each of the parts of NREPA governing the issuance of a permit, whether it's water pollution permits, air pollution permits, inland lakes and streams, or wetlands, or whatever else it might be, there will be a section of the act that provides for your appeal to the agency. Similarly, if it's the liquor control code, if it's the public health code with all those COVID orders that a lot of folks were challenging last year. Those are decisions that there will be a statutory provision providing for an opportunity to take an appeal to the administrative agency and to give them an opportunity to change their mind or to correct a mistake. When do you need to act on these? Well, that's kind of the thing that becomes an issue for a lot of clients is they'll bring you something and they'll say, well, a couple of weeks ago I got this decision, or somebody sent me a letter in the mail. What can I do? And the turnaround time for many of these administrative remedies is very, very short. There are, in some instances, 20-day or 30-day or 60-day timelines. You may, if you're lucky, have up to 90 days. But for the most part, you're looking at 20 to 60 days to take that decision to the agency level. So where do you go? Well, you're filing within what's called the Michigan Office of Administrative Hearing and Rules. It was formerly known as MAS, the Michigan Administrative Hearing System, and now is called MORE because it is not simply MAS. It also has, as we'll talk about later, the Office of Regulatory Reform combined with it, or Office of Regulatory Reinvention under Governor Snyder. And it is so now the Michigan Office of Administrative Hearing and Rules because it performs functions with respect to both the hearing system and with respect to administrative rules. It's a type 1 agency. It's created by executive order, and it's staffed by administrative law judges, many of whom have special expertise with respect to one particular area. They're generally assigned to an area predominantly, but sometimes they're floating among different areas of law, and so they might be dealing with a number of different agencies. What does a petition look like? Well, it's going to depend on the substantive statute that the agency decision is based on. Some petitions have to be sworn, so you need to have them verified and notarized. That's the case under NAREPA for Part 31 petition. Some are pretty simple and might be as little as filing a one-page notice saying that you're contesting a decision and referring to the nature of the decision and asking for a hearing. It's going to depend on both the substantive statute and the administrative hearing rules. So, for instance, there are rules governing appeals involving EGLE, and those generally are in the middle ground. They say you need to state the facts or conduct that warrants a contested case. You don't necessarily need to lay it out like a complaint, but you need to say enough to explain why you're there. Some are much more complaint-like. At the tax tribunal, for instance, it adopts what is essentially the same standard as is applicable to filing a complaint. Says you need a statement of facts without repetition upon which you rely in making your claim of relief. So it'll look more complaint-like. What do you expect when you get to more? Well, these are trial-like hearings. In many instances, they provide what amounts to a trial and will give you a full opportunity to present evidence from witnesses and documents. And often, if there are significant legal issues to be raised, will allow you to file post-hearing briefs. So some of these are very short, very truncated. It's just a matter of getting on a couple witnesses. Some of them could be 1 or 2 week long trials followed by a lengthy briefing schedule. So just as much litigation as a civil bench trial. The procedures are set forth under the APA. I have given you the citations there, generally starting at 271 to 288. There's also the uniform hearing rules, which I've alluded to before. And those have general rules for most cases, and then specific rules for certain agencies like EGLE or the MPSC and other agencies. Usually you're not getting discovery. You're not going to depose any witnesses before you get to this quasi-trial. Instead, you're going to have to conduct your evidentiary hearing just knowing what you know from the documents. You will often get the administrative record, the file that the agency has with respect to the decision they've made, which might include a report, might include just the letters that have gone back and forth between the agency and your client. Or, it depends on the substance and the nature of the particular decision you're appealing. You can subpoena witnesses if you need to do so, though for the most part, talking to the AAGs, you should be able to determine whether or not the particular folks that you want from the agency are intended to be there. And often there's a pre-hearing conference to figure those kinds of questions out. There is a loosened evidentiary standard. It's a bit of a contradiction here. It says the rules of evidence as applied in non-jury trials shall be followed as far as practicable, but an agency may admit and give probative effect to evidence of a type commonly relied upon by reasonably prudent men in the conduct of their affairs. So the question is, what exactly does that mean? In practice, it tends to mean that the agency can bend the rules to hear the evidence that they need to hear. However, how much they do so really depends on things like the level of sophistication of the parties and what is at issue. Usually that's going to favor your client, not the agency, but it can go both ways. And the bottom line is, number one, that this is a quasi-judicial proceeding. It's not a judicial proceeding, so there is that level of flexibility. And number two, that the foundation of these hearings is really in giving your client due process. And so there's a flexibility for the administrative law judge that's intended to achieve due process. So assuming you get a decision from the agency following a contested case, which usually involves a written decision or a proposal for decision that might go from the ALJ to somebody within the agency who has a final decision-making authority, what happens next? How do you get to court? Well, as I mentioned before, the Constitution gives you the right to take that final decision to the circuit courts, to the judiciary, and to have judicial review. And so if for some reason the underlying statute doesn't give you a right, the Michigan Supreme Court actually held in Midland Cogeneration Venture that statute would be unconstitutional. And that was a state tax commission case. And certain decisions by the state tax commission were not reviewable. And they said, no, the default is you have to have review if it affects private rights or licenses and it's quasi-judicial or judicial. And so if there's no statute on point, what's going to govern is the Revised Judicature Act, the RJA. So your three options are potentially, as mentioned in this quote from this Jackson Community College case, either there's a method provided by the substantive statute, or there's a method of review prescribed by the APA, or your default is the RJA. So looking at those a bit in more detail here, for starters, the substantive statute could be pretty duplicative of the APA. And I've quoted here Part 301 of NAREPA, which says you can seek judicial review in the same manner as provided in the APA. So it's not saying anything different than if you were to take an appeal under the APA. But it could be different. So you do need to consult that underlying statute. Then there are the provisions of the APA, which we'll talk about in a little bit more detail in a minute, which provide your right to appeal to the circuit court. And then there's the catch-all under the RJA. So filing in circuit court, some folks mistake this as an original action. They think, okay, this is just like anything else. I'm challenging an agency decision, but I'm filing in circuit court, so they will file a complaint. And that is not the case. Instead, this is not an original action. This is a true appeal. There are court rules providing for your appeal to the circuit court, and you're filing either a petition for review or what amounts to an appellate brief. And so there's specific procedures that are set out for certain types of agency actions. I've listed some of those there, like the Michigan Civil Service Commission, the Parole Board, licensing appeals. And then there's these general provisions for appeals governed by the APA or not governed by the APA. And that sets forth things like, whether this is a brief or what your options are for maybe supplementing the record. And it also sets forth things like your timing of when you need to file this. And the question there, when do you file? Again, the answer is now. It's as soon as possible, because you're going to get a decision, talk it over with your client, and then find out that you only have either a 21-day period if it's under the APA, or maybe a 60-day period if it is non-APA. So it's not a lot of time to make that decision and to start putting together your challenge after you receive that final decision from the agency. In terms of what your scope of review looks like, there is, if you're doing this under the APA, there's a provision under the APA that sets forth what at a minimum must be included in any judicial review. Is the agency decision in violation of the Constitution or statute? Does it exceed their authority? Was there some unlawful procedure that has prejudiced you? Was it supported by competent, material, and substantial evidence? Was it arbitrary and capricious, or was there some other substantial material error of law? Generally, those are going to present de novo questions. Not always, though. The two main exceptions. One is this arbitrary and capricious standard. It is a legal question but the standard is very high. You do have to prove that the ruling lacks an adequate determining principle, reflects absence of consideration or adjustment with reference to principles, circumstances, or significance, or is freakish and whimsical. And this actually formulation of it in this Westcoff case is, if anything, a little bit more favorable to those challenging than what you usually see. You usually see this question of, is it freakish or whimsical? Is it, done without reason? It's a very high standard and difficult basis to bring a challenge. Now, maybe it shouldn't be such a high standard. Maybe it doesn't have to be. Arbitrary and capricious is actually defined at the federal level in a different manner. And arbitrary and capricious, at least when you're challenging administrative rules that have been promulgated by the federal government, that although it's a narrow review, it is a review that asks some significant and substantive questions like, is there a rational connection between the facts that you found and the choice that was made by the agency? So is the agency decision warranted by the facts that they found? Was the decision based on a consideration of relevant factors? So did they actually look at all the things they were supposed to look at? That's a standard that arguably could be adopted in Michigan as a definition of arbitrary and capricious, but it's not currently what Michigan appeals look to in terms of what's arbitrary and capricious. That's this high freakish or whimsical type standard. So again, on the scope of review, one exception to de novo review as well is fact findings, and that is they're reviewed under a highly deferential substantial evidence test. So substantial evidence is evidence that is less than a preponderance. It says that it's that which a reasonable mind would accept as adequate to support a decision, more than a scintilla, less than a preponderance. So very, very deferential. Would a reasoning mind accept it as sufficient to support a conclusion? Kind of a vague standard, but ultimately in terms of how that's reviewed, it's going to be up to, it's going to be reviewed on basically a clear error standard in terms of, if the circuit court overturns an agency's decision and it's further appealed to the Court of Appeals, the question will be, did they commit clear error in applying that standard? So that's agency appeals, but what if your remedy here is to sue the state, whether you're bringing a declaratory judgment action or you have a monetary claim against the state? What do you need to know? Well, as a starting point, you need to know that the place you're most likely to sue the state of Michigan is at the Michigan Court of Claims. It has exclusive jurisdiction, except in certain limited circumstances, to hear and determine any claim or demand, statutory or constitutional, liquidated, unliquidated, ex contractu or ex delicto, against the state, its department, and its officers, notwithstanding that there might be a law out there that says otherwise. And so that is extremely broad. The main exceptions here are, number one, that it says that you, if you have a right to a jury trial, that's not taken away. You're still going to have an opportunity to present your case to a jury. And so you will have concurrent jurisdiction as between the Court of Claims and the Circuit Court. That's provided under 6421. Another exception, and this one's currently being litigated by the state, and that is if you have a federal remedy. So what does it mean in terms of having a federal remedy? It means that you're able to actually bring a suit, notwithstanding maybe the 11th Amendment considerations. You're able to actually bring a suit in federal court, in which case the way in which the statute is framed is a little bit awkward, because it says that it starts with this presumption of exclusive jurisdiction as at the Court of Claims, and then it says that if you have a federal remedy, that you have to pursue that elsewhere, that the Court of Claims doesn't have jurisdiction over that. And so the question has become, can you pursue that federal remedy in 1983 suit or something else? Can you pursue that in federal or in circuit court, or do you have to pursue that in federal court exclusively? And that's currently being litigated. There's a case of McKenzie versus Department of Corrections that's pending at the Michigan Supreme Court, and is asking that question of whether you still can sue in circuit court. So where and what is the Michigan Court of Claims? Well, historically, the Michigan Court of Claims was in the Ingham Circuit Court, and it was limited to cases involving money damages, not injunctive or declaratory relief. That was modified, though, in 2013 by PA 164, and that broadened the Court of Claims Act and its jurisdiction to include, as mentioned before, almost everything, or practically everything other than those administrative appeals. It also placed the Court of Claims in the Michigan Court of Appeals, and it's staffed by 4 Court of Appeals judges, and those are assigned by the Michigan Supreme Court. They have 2-year terms that are ending every May of every odd numbered year, and they can be reassigned. And so some judges have been there for a while, and some serve a 2-year term and then are rotated out. There are local administrative orders on case assignment, as well as local court rules that you have to be aware of. And it's up for debate whether or not this is the best solution, because there's currently proposed legislation under HB 4222, which is pending, that would change the nature of the composition of the Court of Claims and instead have it staffed by circuit court judges from around the state. So there are some statutes out there that contradict the Court of Claims Act. For instance, there is the Revisedjudicature Act, which says that if you're going to sue on a Headley claim, you actually can sue in circuit court or in the Court of Appeals. And that provision came before the Michigan Court of Appeals recently, and it held in 2019 in this Telford case that because the Court of Claims Act is so broad, and PA 164 of 2013 evinced an intent to take up a lot of that space or all of that space, that it impliedly repealed the provision of the Revisedjudicature Act that still allowed you to sue elsewhere. That's still an open question then for things like the APA, which provides that you can sue in circuit court when you're challenging an administrative rule, the validity of an administrative rule. But most likely, you're going to have to sue in the Court of Claims if you're challenging state action, even if there's a statute out there that says something else. So if you're suing the Court of Claims, one thing you need to be aware of is, again, going to that question of did your client come to you with enough time to do what you need to do? There is this notice of intent requirement. And the notice of intent requirement says that if you're going to sue the state, you will need to file this notice that tells them why you're suing or why you intend to sue, what the nature of your claim is, when it arose, and things along those lines. And the time for doing so is, for most claims, 1 year, but for some claims related to personal injury or property damages, you have to file within 6 months. So it is not a lot of time to get your notice in. It does not mean that you have to file suit in that time, but you have to file either the claim or the notice. And so if you filed suit, you're good. You don't have to have a separate notice. But if you don't want to or can't file suit that quickly, then you need to file your notice and just park it as you prepare your suit. So another provision that you something else kind of just to note here with respect to the notice of intent is that this is in fact a prerequisite to filing suit. So it's been held that it's basically part of your the state's immunity from suit, and so you have to file that notice, otherwise your claims could be barred. There's no savings construction, so they can't say, well, was the state really prejudiced by this? If you didn't file it, you didn't file it, and your suit very likely could be barred. But it is subject to the RJA tolling provisions. So if there's a basis on which you could toll your statute of limitations under the Revisedjudicature Act, then you can toll your notice of intent. The other thing to note here is you do have a very short statute of limitations. So you have just 3 years to file your suit against the state. That can be a lot shorter than what you might have expected based on your the nature of your claim. You might have thought you had 4 or 6 years to sue, but no, the state is only subject to suit for 3 years. So again, this is subject to RJA tolling, but the bottom line is you'll need to get your suit in quickly. So let's pivot a little bit to administrative law concepts. What are the things that you need to know if you're challenging agency action, or you're simply dealing with a situation where there's some agency action in the background? I'm going to talk about three things, as I mentioned before. And the first is just the nature of administrative agencies as having limited authority. The case law says they have no common law power. You don't have, excuse me for a minute, you don't have power unless it's expressly defined in the statute. And so the powers that are granted by statute cannot be extended by inference. An agency may exercise no greater power than that specified, and it has to be specified by clear and unmistakable language, since a doubtful power does not exist. That's what the Michigan Supreme Court and Court of Appeals have said with respect to the scope of the agency's authority. So if the act doesn't grant that authority, it doesn't exist. And that may be a basis for challenging what the agency is doing in the problem presented by your client. The other concept to be familiar with is the concept of an agency rule. And you'll need to know, when is a rule a rule? Well, a rule is defined in a very broad sense. And it's defined simply as an agency regulation statement, standard, or policy, ruling, or instruction of general applicability that is implementing a law that the agency administers or enforces. It's intentionally broad. And the reason it's intentionally broad, as stated in the Detroit-based coalition case, is so that an agency is not going to circumvent rulemaking in taking an action. So it's not going to label something as a bulletin, a guideline, an announcement, and then enforce it as though it is a requirement. If they're going to enforce it, it needs to be promulgated. Otherwise, it does not have the force and effect of law. And in fact, depending on the situation, it may be invalid altogether, and they may be forced to engage in promulgation. So if a rule is not promulgated, doesn't mean it's not a rule, because this is a broad definition. But if it is not promulgated, it does not have the force and effect of law. Only a properly promulgated rule has that force and effect. Sometimes, as I mentioned, you can invalidate a rule because it wasn't promulgated. For instance, there's case law involving standard form contracts that were held to be rules within the general definition, and therefore needed to be promulgated instead of just enforced against any entity that was engaged in doing a certain line of business. There's also case law involving permit conditions. There was recently a decision where at the Michigan Court of Claims, where some guidance given by the Secretary of State was determined to be an unpromulgated rule and therefore invalid for that reason. So from time to time, you can challenge something as being a rule, but not having gone through the promulgation process. You'll also see sometimes a distinction in case law between legislative and interpretive rules. And interpretive rules, legislative rules are those that have been promulgated and therefore have the force and effect of law. Interpretive rules are really not rules in the sense of being binding. Oftentimes it's guidance, but it's a confusing vernacular that sometimes you have to sift through to figure out what's really going on. So what's the process for promulgating a rule? It is a quasi-legislative process adopted to quasi-legislative actions. Since the adoption of a rule by an agency as the force and effect of law, they're effectively acting as a legislature and filling in a gap somewhere in the statutes. They have to engage in the same kind of process that would be seen at the legislature, where they get public comment, public feedback. It's an open process, and there's an opportunity for engagement to affect the ultimate outcome of what's adopted as a rule. So that starts with a request for rulemaking. They have to explain the nature of their authority, the problem they intend to address, and their assessment of the problem. They have to provide notice and a public hearing, opportunity for folks out in the public to comment. And so oftentimes, if you're representing somebody who has an interest in the outcome of rulemaking, you might want to be submitting comments on the technical nature of what they're proposing, the costs that it's going to impose, things along those lines that are relevant to the rulemaking process. They have to draft a regulatory impact statement and cost benefit analysis. So they have to explain what do they expect to be the costs here, and who is it going to affect? What's the effect on local governments? Is there any conflict with existing law? That sort of thing. So it's intended to make them think hard about the process and vet the rules before they get promulgated. There's also feedback from the Joint Committee on Administrative Rules, which is staffed by members of both houses of the legislature. But there's been case law that says that they can't have a veto right over the executive rulemaking because that would be a separation of powers problem. If you're going to challenge an administrative rule, there is a way to do so, challenging either the validity or applicability of a rule on either a substantive or procedural basis under the Administrative Procedures Act by bringing a declaratory judgment action. So the substantive validity is basically, do they have authority? Is this arbitrary and capricious? Is it within the scope of their enabling act? Is it contrary to the legislation, what the legislature has done? You know, is there a statute that it conflicts with? And that can be raised at any time. One of my cases, Detroit Edison Co. versus Treasury, there was a challenge successfully to a longstanding administrative rule. And it was brought, 30, 40 years after the rule was in place because the statute had changed and the agency therefore couldn't continue to rely on the rule because it was inconsistent with the statute. There are those kinds of opportunities to challenge an administrative rule at any point if it's being enforced against you. Procedural validity, though, has to be brought within 2 years. MCL 24243 says that you can bring a challenge for procedural validity on bases that public comment period, the notice, wasn't consistent with the statute, or that it didn't comply with some other procedural mechanism within the APA. In terms of what all that encompasses, 24264 actually suggests that might include even the cost benefit analysis and how accurate that analysis is. But it's an open question as to how broad can a procedural challenge go and when you can successfully challenge that. With respect to the question of deference to administrative decisions, well, this is the Rovis doctrine, and this is distinct from the rulemaking question. So, does Michigan defer to administrative agencies' interpretations of the law? Well, this is not something that comes into play when we're talking about promulgated rules. As mentioned, those have the force and effect of law. This also is not a question of quasi-judicial fact findings. That's the substantial evidence standard. And then it is, what we're really looking at here is when an agency has made a legal interpretation, either through guidance or through some other document, and maybe in a contested case decision. And what weight do we give to that legal interpretation? That's what Rovis is about. And the short answer is Michigan does not defer to administrative agency interpretations of the law. The Rovis case specifically said courts may not abdicate their judicial responsibility to interpret statutes by giving unfettered deference to an agency's interpretation. So they said, as a matter of the judicial role, judges need to make that call as to what does the statute mean. But as we'll see, it's not maybe that clear cut. Judge Joan Larson, no relation, and former Justice of the Michigan Supreme Court, now U.S. Court of Appeals judge, she took Rovis to mean that Michigan courts are untethered from an agency's interpretation. They have to make their own de novo review of the statute. I think that's probably what the Rovis court thought in terms of what they intended their standard to be. But the long answer is it's complicated. Rovis defined this respectful consideration standard as by saying that the agency's interpretation of statutes entitled to respectful consideration, and if persuasive, should not be overruled without cogent reasons. So it's that second end of it, should not be overruled without cogent reasons, that a lot of lower courts have had trouble with, including many decisions of the Michigan Court of Appeals. One that I put up there is very recent, which says, contrary to the non-deference statements in Rovis, we generally defer to an agency's administrative expertise. That's the Airgas Specialty Products case. And it's not alone in saying that. Michigan Court of Appeals cases have routinely said, we defer to an agency, even though Rovis says no deference. And that's because I think, you'll see in this quote that I've got up here from the article that I mentioned earlier, I've written about Rovis. I think it's because that second half of the standard that says, if the agency's interpretation is persuasive, it should not be overruled without cogent reasons. You can read that as meaning we're just going to consider this as persuasive authority. We're going to look at it like we would look at an unpublished decision of the courts. We're going to look at it as if we look at a learned treatise or something along those lines. Or you can read that as meaning I should give it more weight than just, what my fellow judge may have said in an unpublished decision. I should give it special weight because these agencies do have a level of expertise. Again, I think the intent of Rovis is no deference. It's a de novo review of legal questions by the judiciary, but you'll run into a lot of confusion regarding that standard because of the way in which it's been formulated. So that covers what I've intended to cover, and I see that we do have a couple questions in the Q&A. So I'll open it up at this point to any questions that have been asked. So first question I see here, and then if folks want to type something in the Q&A or the chat, I'm happy to answer. But the first question I see is MCL 24-273 applicable to compel testimony at a contested case hearing, or can it be used to compel testimony in a deposition? It really is a procedure intended for contested cases. And really oftentimes, if you're going to enforce that, you might actually have to go to circuit court to enforce the subpoena, because the tribunal, the agency that's handling the contested case is not going to have the judicial authority to give some sort of an injunctive order and compel somebody. They can give you an order saying somebody should be there, but then if you need to enforce, you may actually have to go to circuit court to do so. So if there are any other questions, I'll give folks a minute to type them in or raise those questions. I'm happy to answer. All right, well, seeing none, appreciate the opportunity to present, and feel free to reach out to me. You can find me at the Clark Hill webpage if there's something that comes up afterwards that you think of later, and happy to be a resource to folks. And I hope you found this informative. Thank you very much.